Shreya Ley, we are reviewing the Asset Protection Planning Guide,
The Bible?
what we call the Bible. And Shreya, we've been reviewing the goals of asset protection planning.
All right.
So I want to run through that.
All right.
I'm going to list them out and have some of our thoughts.
Okay,
some of your
perfect.
thoughts. So maybe I'll throw them at you and we'll see what you have to say.
Okay.
You're so well spoken. Number 1, create a user-friendly plan. So they write, planners sometimes too easily forget that most clients are laypersons who must live within the confines of the plan designed for them and deal with it on a sometimes daily basis. Asset protection plans that consist of a myriad of entities designed to obfuscate and confuse third parties may also serve to confuse and frustrate the client. Properly designed structure that works because it is sound in legal theory and operation, rather than because it is complex, is not only better for the client, but ultimately more protective as well. Your thoughts?
Yeah, I think that is one of the things that we often talk to people about when they call us for asset protection planning, is that there are options to cater it to their own needs and their own preferences and risk tolerances. So some people want the most protection and they don't care if it makes their lives a little bit harder. Whereas other people are very adamant that they want it to be the most user-friendly possible with the fewest number of entities possible. And as long as people are aware of the risks associated with any of their choices, we are happy to help them set up a plan that works for them.
Happy to oblige.
Yeah.
Partner. Thanks, Shreya. Number 2, deter litigation. Avoiding the deep pocket syndrome by reducing the size of the target may itself accomplish much in the asset protection context. Wealth is, of course, a target or a magnet for lawsuits in the United States.
It always reminds me of the stories you hear about the people driving the, 30-year-old Jeep, but they happen to be the richest person on the block.
30-year-old Jeep's pretty cool.
30-year-old Jeep is very cool. But
maybe a 30-year-old Honda Civic.
Yeah, or one of those Volvo station wagons or whatever from back in the day.
Yeah.
But yes, that would be my point. And I think that we often preach that as 75% of the battle, at least for the majority of our clients, is the hope is that the lawsuits simply never materialize.
Either it doesn't happen, it doesn't materialize, or it ends very quickly.
Right.
You're not just deterring litigation at all, but also deterring 2 years of litigation.
Mm-hmm.
I skipped ahead of myself because number 3, provide incentive for an early and cheap settlement.
There you go.
Economics drive the legal system. Personal experience proves that much can be achieved by knocking the profit out of the pursuit and by being able to demonstrate to a claimant that being paid is not the given that it was expected to be.
I feel like 2 and 3 are very similar, right?
They are.
I mean, 1 is simply hiding, I guess, your wealth to begin with, in a way, from the public eye. So it's not easily apparent to anyone looking how much you own and what you own. And I think that's great. And I think that also works for number 3, which is that once people start digging, if they see that you have your assets set up in a proper plan, they will realize that it will be very difficult for them to get paid, and they will also choose not to pursue you, which is, I think, what you were saying before.
Yes. Thank you, Shreya. Thank you. Moving on to number 4, level the litigation playing field. A defendant who has no asset protection planning in place will have fewer strategies and defensive maneuvers available at critical points during the course of litigation.
Colin, I think this is your biggest talking point.
We did learn a lot from the Bible here.
True, but I think also it's the idea that we tell our clients that by doing asset protection planning, they're gaining leverage in a lawsuit against them. Whereas without any asset protection planning, they're kind of just at the mercy of the legal system.
Yeah, if you've got no asset protection plan and all of a sudden this plaintiff's attorney shows up, when they show up, you're already bent over the table there. You're just turned around and bent over. Now, say you got an asset protection plan in place. They walk in, you've already got your fists up. You got your knuckles wrapped. Maybe you've got some shards of glass built into your knuckle wraps. You're ready to go. You're ready to fight. I'm just throwing out a little analogy here.
But this is an Albuquerque column.
You got your switchblade open. But right. So without the plan, you feel more vulnerable because you are more.
Right.
You have assets to lose, a clear and easy path for someone to take those assets. Whereas when you have that plan in place, you're like, hey man, what I got. I'm not going to make it easy for you. I got the means to put up a fight.
And I think this we were recently speaking with a bunch of attorneys. We were teaching them about asset protection. And I think that came up is you don't have a duty to make it easy on people to take your stuff from you.
Number 5 is enhance one's bargaining position. Throughout the course of litigation, one who has a well-designed plan in place will have the benefit of a vastly improved negotiating position as a result of the fact that the planning was properly conceived and implemented. So, yes, that's what we're saying.
That is what we're saying.
You got that power. You're like, I'm gonna negotiate with you. I'm gonna offer you pennies on the dollar, as they say.
Mm-hmm.
And you get to do that because you have a plan in place. You put up those barriers and obstacles, right?
Right.
Is that what we've been saying, Shreya?
That is what we've been saying.
Okay. Anything else to add?
No, I think we've already been covering it.
Well, number 6, provide options as the game is played. A well-tailored plan will not tie the client's hands or lock the client into a course of action that must be followed regardless of what happens. This is my favorite part of asset protection planning.
Oh, yes.
I mean, you've got moves to be made. You got the shards of glass in your knuckle tape. You got a switchblade in your pocket.
I think this is the biggest benefits that I tell people about trust planning versus those who rely only on LLCs.
Right.
With something like LLCs, you don't have as many tools and strategies that you can adapt on the fly as things might escalate or de-escalate in any type of situation or threat. Whereas with a trust, you can escalate and de-escalate your plan. You can make changes and adapt to the situation. And there's just so many more tools and strategies available to you to protect yourself and your family.
Yeah. That LLC, all you're hoping for is a charging order.
Right.
Like, I hope all they get is a lien against the distributions that come out for the next 20 years. You know, that's a lot of things it's a lot of eggs for your basket.
In one basket. It's not even in multiple baskets.
There you go. It's all your eggs in one friggin' basket. But yeah, I love that about the trust, that you can bring in new trustees, new trust protectors. You can switch from a U.S. location to an offshore location to another offshore location.
Mm-hmm.
So much can be done. So many options as the game is played.
Yes.
And here we are, Shreya, closing it out. Number 7, win the game. Win the game, Shreya.
Oh, is that it? That's the whole thing?
Yes.
All right.
Obviously, we want to win the game, but so what this is referring to, here, I'll just read the prompt here. Proper planning will create a series of hurdles that the opponent must clear. With the realization that a deep pocket-driven emotional plaintiff may have the stamina and strength to clear the hurdles, the planning must ultimately work because it is legally sound. This is a long prompt, but it is.
Okay, I get what they're saying though now.
Yeah. Another way I've seen this author write it is force the jurisdiction abroad.
Mm-hmm.
So if your fight goes all the way to an offshore jurisdiction, that's when you win. If your assets are offshore, if your trust is offshore, if they go there to try to get your assets there, they're not going to win.
Right. I think that is one of the first things we used to tell people about with LLC planning versus trust planning, and particularly with offshore trusts, is that when it comes to deterring lawsuits, maybe a domestic trust does an equally good job as an offshore asset protection trust. But when it comes to actually surviving litigation, having that offshore planning is really going to help you win that game.
Then you get a fist bump, high five. That's all, Shreya.
Great.
Thanks for listening, and see you next time.
See ya.